being back at home. It's a real privilege. And during the next 15 to 20 minutes max, I will introduce you to the smart contracts. And I want to share with you three ideas, three issues that I have faced when making my research about smart contracts. But I want to focus especially in the algorithmic formation of smart contracts and the challenge that they pose for smart contracts and for contract law. Although the idea of smart contracts have been out there for a while, they became known when the Bitcoin appeared, and some saw that the capabilities behind the cryptocurrencies were also useful for other purposes. But the idea of smart contracts came to life in 1994 and was introduced by Nick Szabo. He was a legal scholar, a cryptographer, and a computer scientist who envisioned that somehow the law could be embedded in computer code. So let's start from the beginning, and let's present you the smart contracts. What is smart contracts and why is important for contract law? Szabo originally defined smart contracts as a set of promises specified in digital form, including the protocols within which the parties perform on these promises. But the idea of smart contracts, as I said, evolved with the development of the blockchain and other distributed ledger technologies. And since then, smart contracts are understood as digital agreements written in computer code, run on the blockchain, and automatically executed without any need of human intervention. But coming back to Szabo, he specifically pointed out that the idea behind the smart contracts was that many kinds of contractual clauses could be embedded in the hardware and in the software we deal with in such a way to make the breach of the contract expensive for the breacher. His idea was to take the traditional contracts and translating them into code through cryptography, messages, and algorithms, and running them in the internet to replace the traditional paper-based business relationships. But the fact is, once we move beyond Szabo definition, there is not unanimity of what is understood as a smart contract. There is not unanimity in their classification, there is no unanimity about their legal nature, and even to make things more complicated, the term is used both to refer the technology and also the applications built on the technology. There is a vast amount of information published about smart contracts, but it's super diverse. You can find computer scientist papers, legal scholars' contributions, and blogs. Also, the states have started to have a say about smart contracts regulation. For example, Italy and Estonia have started regulating smart contracts, and specifically in Spain, in May 2021, a non-legislative motion on the use of blockchain was submitted to the Spanish Parliament, which makes several references to smart contracts, and specifically that they are not only subject to the civil code, but also to the provisions of the Article 23 of the Law 34/2002 on information society services and electronic commerce. But as I said at the beginning, there are three issues that I want to share with you today, the ones that I have faced and consider more important when researching about smart contracts. The first relates to the so-called smart contract self-enforceability. I felt that I was swimming against the flow because I don't think that smart contracts are self-enforceable. I think they are self-executed, they are unstoppable, they are tamper-proof digital agreements, but they are not self-enforceable. The second idea, in which also I will explain a bit more depth later, is that contract law is more than remedies. It's also about setting the requirements for a contract to be legally binding. And the third is what happens when algorithms are involved in the contract formation. So starting with the self-enforceability of smart contracts, as I said, the tamper-proof, unstoppable, and automatic performance are smart contracts' main features. But in my opinion, algorithm perform smart contracts. Algorithms technically guarantee the performance, but they do not enforce them. Only when there is a dispute over a contract is when there is a need of enforcement. So, although these automatic, tamper-proof, unstoppable characteristics will diminish the number of disputes, things always can go wrong, and especially when we move between the real world and the virtual one. And terminology is important, and is especially important when we are in an interdisciplinary field as this is. And it's important because this idea of smart contract self-enforceability that I have found very much repeated has led even to legal scholars to say that with smart contracts, there's not going to be a need of relying in courts to obtain legal protection. I think Szabo, the original creator of the smart contracts, is the one who led to this misconception when he said that there is a self-enforcing protocol. But the term self-enforcing used by Szabo has little to do with contract law. From the law and economics perspective, self-enforcing means that each party can decide unilaterally when to stop the relation with the other party. And from a legal perspective, enforcement is the protection, and none of these things happens in smart contracts. The second idea is about that contract law is more than remedies. Many scholars, as I said, argue also that with contract law, there is not, with smart contracts, there is no need for contract law because litigation will disappear due to this self-enforceability that I have referred before. For them, contract law is mainly about remedies, and therefore, smart contracts and contract law are like oil and water, nothing in common, but they forget about the ex ante role of contract law. Contract law also provides with the requirements for a contract to be legally binding, to become legally enforceable. So we have to move to an ex ante assessment, and we have to work in smart contracts design. The third point, and in which I will focus more today, is about the algorithmic contracts. What happens when decisions are taken by algorithms? We've been speaking about this topic a lot during these days. That is why I call the paper moving towards the dehumanization of the contract formation phase. It sounds a bit apocalyptic. We are not there yet, at least when it comes to smart contracts, but we have to consider also this situation. As I have said before, the algorithms intervene in the execution part of the smart contracts, making it automatically, but also can intervene in the formation phase of the contracts, replacing the meeting of the minds. And therefore, what I've done in my paper is analyzing how the requirements of a contract to be legally binding fit in this scenario. So we have to distinguish between two types of smart contracts. Those that are formed in the analog world with the normal and traditional meeting of the minds, the bargain out of the online system, and then those that happen without no prior offline negotiation between the parts. And this is crucial because in smart contracts, one of the characteristics is that by signing the contract, automatically and irreversible set in motion the execution of the agreement. No revocation is possible. So what happens when we speak about algorithmic formation of smart contracts? So I'm referring to those situations in which the algorithms determine the obligation of the contracting parties. Is is the case of the use of the so-called algorithmic contract. This is a term coined by Lawrence Schultz, and entering the arena of the smart contracts formation. Nowadays, computers are programmed to trade without any kind of human oversight and to respond to market informations in real time and to enter into transactions when simply certain conditions are set and are met. In this sense, the fulfillment of the offer and acceptance requirement have a legal fit in the algorithmic smart contracts, since the system is limited to a priori matching the indications in which have been programmed. And in this sense, algorithms are understood as mere tools. But the difference comes in the fact that contract law is not designed for those cases in which the contracting party outsources the process of evaluating the possibilities in the pre-contracting phase of the contract to an algorithm. And this is the case of the artificial agents. And there are two potential problems that have to be pointed out in regard of them. First is that the results achieved by the algorithm are not those that would, for example, have been achieved by the subject in whose behalf it acts. And the second is the possible illegality of the solution adopted by the algorithm. But algorithms also can be classified not only do its role in the contracts formation, as I said, acting as mere tools or artificial agents, but also in relation to the task assigned as gut feeling or negotiation. And even moving further, we have to consider and to reflect about the clear box and black box algorithms, depending on whether the outcome of the decision taken by the algorithm can be or not anticipated by its principal. Having established this classification, I have to say that the mere tool algorithms and the gut feelings algorithms have a more straightforward legal fit in contract law, but the situation is really different when we are speaking about the negotiation algorithms, and especially if they are black box algorithms. At this point, what I've done in my paper, in my research, is consider Lawrence Schultz analysis with respect to algorithm contracts, but trying to apply them for especially smart legal contracts formation. What she shows is that while the formation of the contracts may comply with the object intent of the contract, the formation theory has some drawbacks, such as an absolute rationalization that doesn't happen offline, and uncertainty, avoidance of accountability, and the breakdown of the balance of the power between the parties that falls for sure for the side of the one using the algorithms. So the question is, what happens when the algorithm might have changed the human intention in which was originally programmed? So in order to overcome these drawbacks, she also tried to apply the law of agency by analogy in regards to the contract law for algorithmic contracts, but she also highlighted, and I think that's special and it's the clue, that there's no human decision behind the algorithm decision, and the law of agency is not prepared for that kind of decisions. It's just prepared for human decisions. There is no person behind the decision acting on behalf of another one. There is a machine decision. So in order to solve this, she proposes that algorithms, since they cannot be considered human agents, could be considered agents without personality or quasi-agents. And to this end, she presents three mechanisms to achieve this enforceability of algorithmic contracts by real-time updates insurance mechanisms and the introduction of a human approval node for each transaction. But in my opinion, when applying this theory to smart contracts, there are some drawbacks that should be highlighted. The first one is that this real-time updating of human approval nodes could pose a delay for the process of automation and rapid decision-making that the use of algorithms intend to overcome. The second is that problems could arise with combining with this delay, this delay in ratification with the impossibility of stop the execution. What happens if, when you are going to not confirm the operation, it has already started? And finally, the insurance mechanism that she offered as a solution implies neither agreement nor ratification, which are requirements for the agency law to create agency relationships. So at this point, and I reached the end of my presentation, I think there is a very difficult fit between the algorithm contracts formation and their applicability to smart contracts. I think it's an ongoing issue that I have identified during my research, and I suggest that much more research has to be done in algorithmic contract formation to be applied to smart contracts. And thank you very much, and I'm looking forward to listening to your comments, suggestions, or questions.
So many thanks for this fantastic exposition. Really interesting for people who are not private lawyers, I think, or especially for people who are not private lawyers like me. We were last week discussing a bit about some of the issues that you have just commented. That's why I'm not going to ask you for the moment anything, and I am going to leave the room and the opportunity to others. Is there any question? I don't see you. Ah, sorry.
First, thank you for the great explanation. And I have two brief questions. The first one is that maybe we can call the smart contract as a contract without an agreement or negotiation without an agreement, because maybe there's no dialogue. So the algorithm establishes everything for both parties. So we can call it contract because, for example, in Italy, but I think also in Spain, the agreement is one of the main elements of the contract. But here, there's no agreement. And the second question is if the algorithms are owned by someone, like banks, but they establish everything without the possibility also for the owner to foresee where they will go. And some, for example, in COVID, so in the long-term contracts, they will go in the direction not foreseeable for anybody. So who is reliable for this decision?
Yeah, thank you for the questions, are really interesting. Regarding the first one, there are two different situations, and that's why in the literature and in my work we are distinguishing between these smart contracts, which I call mixed analog smart contracts, in which the meeting of the minds and everything happens offline and they are translated into code. And so far, this is what is happening. I mean, there are not yet pure smart contracts which are written directly in code and in which the parties haven't met offline before trading. But we analyze them because the movement seems that can be towards that direction. But definitely it's difficult to meet the requirements of contract law when there is not this human intervention in meeting the minds. It's more difficult to call them agreements, although if they are following the instructions provided by the programmer of the algorithm, some scholars states that here it comes, the meeting of the minds, no? It's more complicated when they, as black box algorithms, take decisions that we don't know in which bases are taken. The decision or the election done by the algorithm can be different by the one done by the programmer. Yeah, in that case, what I've read, but I don't have an answer yet, some scholars are stating that we have to find maybe a way of having third parties programmers liability if what they have written is not according what the instructions given to them. So there's not a solution yet. And the thing is that these smart contracts are working in finance, but they haven't reached any court of justice yet. If any problem has been out there, they have solved with other mechanisms. So there's no answer yet to that question.